Nolan Wells update. Is an arrest finally coming? District Attorney speaks out. An 18-year-old went to an island on July 4th. His friends came back. He didn't. 2 days later, Nolan Wells' body was pulled from the water off Horn Island, Mississippi. And from that moment forward, almost nothing about this case has added up. Here is the first thing you need to know. Not background, not history. The first hard fact. It took 13 hours before the Coast Guard was contacted. 13 hours. A teenager is unaccounted for on an island. His friends are on a boat. And for 13 hours, nobody made that call. That number is where this entire case begins to crack. Now take a look at this for a moment. Nolan Wells was 18 years old. July 4th, a boat trip with friends. The kind of day that sounds completely ordinary, until it isn't. The group made their way out to Horn Island, a barrier island off the Mississippi Gulf Coast, accessible only by water. No bridge, no road. You get there by boat, and you leave the same way. At some point during that trip, Nolan went missing. His friends were aware. They were on the same boat, on the same island, and yet the Coast Guard was not contacted for 13 hours. Not 30 minutes, not an hour while they searched. 13 hours. Here is the documented sequence of events. The boat returned to shore. Nolan's mother reported her son missing. That report is what triggered the search. Not a call from the boat, not a call from his friends. His mother, from shore, because her son never came home. Think about what that sequence means. The people who were with Nolan came back without him. They were back on the mainland. And the first formal report of a missing teenager on a remote island came from his mother, who wasn't even there. Okay, stay with me, because this is where the evidence starts layering in. The boat that went to Horn Island that day had GPS tracking on board. That is a documented fact. GPS technology logs exact position data. Every stop, every movement, every location. How long the boat was anchored in one place. What route it took. What time it arrived. What time it left. All of it. Logged, time-stamped. Investigators have that data. Now here is why that matters. The friends who returned to shore gave investigators a verbal account, a version of events, a timeline of what they say happened on that island. GPS data either lines up with that account, or it doesn't. And that distinction carries serious legal weight. In criminal investigation, when a witness account contradicts physical tracking data, that creates what is called probable cause. Probable cause doesn't mean proven. It means there is enough documented, reasonable evidence to believe a crime may have occurred. It is the legal threshold required to make an arrest. Not a conviction, an arrest. If that GPS data tells a different story than the one investigators were given verbally, that gap alone enters probable cause territory. GPS doesn't get nervous when a detective asks a follow-up question. GPS doesn't adjust its memory of what happened. GPS doesn't forget. Witnesses can do all three. Now watch this. Because the GPS is not the only piece of physical evidence in play here. A phone was recovered. That is a confirmed, documented fact. A phone was found, whose phone it belongs to, exactly where it was recovered, and what is on it have not been released publicly. But here is what you need to understand about what investigators do with a recovered device. When law enforcement recovers a phone connected to an active investigation, the first step is extraction. Digital forensic specialists pull everything from that device: call logs, text messages, app activity, photos, videos, but it goes deeper than that. Cell tower data shows which towers that phone connected to and when. That creates a location history completely independent of what anyone says verbally. Last activity timestamps show exactly when the phone was last used. If a phone goes dark at a specific time on July 4th, and that time contradicts the timeline investigators were given, that is evidence. And there is one more layer to device data that most people don't think about. Even deleted content can often be recovered. Forensic tools can pull data that the owner of that phone believed was gone. Messages erased, photos removed, search activity cleared. None of that is necessarily permanent once investigators have the device. So right now, inside this investigation, there are at minimum two sources of physical data that either confirm or contradict the verbal account investigators received: the GPS record from the boat and the data from the recovered phone. Neither of those sources can change their story. Now let's come back to Nolan for a moment, because he is not just a name in this case. He is the reason every single piece of this evidence matters. 18 years old, July 4th, a day that should have ended with a boat ride home. His mother waited for him. He didn't come back. And for 13 hours, while she didn't know where her son was, the people who did know were not calling for help. That 13-hour gap is not just a number. It is a documented window of time. And inside that window, decisions were made by someone about what to say, about what to do, about when and whether to call for help at all. The Coast Guard's own contact records document exactly when that call came in. That timestamp exists, and the distance between that timestamp and the moment Nolan went missing on that island is sitting at the center of this entire investigation. 13 hours is not confusion. 13 hours is not panic. 13 hours is a decision. And that decision is one of the first things the people inside this investigation want to understand. Here is what we know with certainty so far. An 18-year-old is dead. A 13-hour gap exists between his disappearance and the call for help. GPS data from the boat is in the hands of investigators. A phone was recovered and is part of the active case file. And the friends who were with Nolan that day came back to shore without him. What we don't know yet is what the DA found when she looked at all of that together. But the way she responded to it, the way she sealed evidence, silenced investigators, and chose her words very carefully, that tells you she found something worth protecting. Before we get into what the DA actually did and why every single decision she made signals where this case is heading, take a second right now and subscribe to Detective Crime Hour. Here is why this matters specifically for this case. The grand jury has not convened yet. Toxicology results are still outstanding. This case is still moving. And when it breaks, it is going to move fast. If you are not subscribed with notifications on, you will be catching up instead of following in real time. Hit subscribe now, then stay right here. Because what the district attorney did next is the most important part of this entire story. And most people completely missed what she was actually saying. What the DA is actually building. 3 weeks. That is how long District Attorney Angel Myers-McElrath said nothing publicly. No press conference, no statement, no acknowledgement. A teenager was dead, a family was waiting, and the DA was silent. Then July 23rd arrived, 3 weeks to the day after Nolan's body was recovered from the water. McElrath released a video statement addressed directly to the people of Jackson County. And when you hear what she confirmed in that statement, and what she deliberately left out, the direction of this investigation becomes very hard to misread. She confirmed 3 specific things. Each one matters. Each one tells you something different. Let's go through them one at a time. The first thing she confirmed was this. Every single investigating agency on this case was ordered to stop making public statements. All of them. Done. Silence. A reporter tracked down the Jackson County Sheriff outside his office this week and asked him directly about the case. The sheriff's response was exactly 3 words. Actively under investigation. That's it. That is legally all he is permitted to say now. Here is what that order actually means in legal terms. When a district attorney issues a directive restricting all public comment from law enforcement agencies involved in a case, it is called a prosecutorial communication restriction. It is not a routine step. It is not standard procedure in accidental death cases with no open questions. Prosecutors issue that kind of order when they believe public statements from investigators could compromise evidence, contaminate witness accounts, or interfere with grand jury proceedings. You don't silence an entire investigative infrastructure around a case you're preparing to close. You silence it when you are protecting something you intend to use. The second thing she confirmed was the sealed autopsy. And this one requires you to stop for a moment. Nolan Wells' own parents cannot see the autopsy report of their own son. A sealed autopsy means no access. Not for the family, not for the public, not for defense attorneys at this stage. Now here is the distinction that matters most here. Autopsies get sealed for 2 very different reasons. The first is protective. Sealing prevents sensitive forensic details from becoming public before a case is prosecuted. It protects the integrity of a future trial. The second is strategic. Sealing locks down findings that, if released, could alert a subject of the investigation to exactly what law enforcement knows. In a straightforward accidental drowning with no suspicious circumstances, there is no forensic detail sensitive enough to require sealing the autopsy from the victim's own family. The fact that this autopsy is sealed tells you the findings inside it are being treated as active investigative evidence, not a formality, evidence. The third thing she confirmed was the grand jury referral. And this is where a lot of people following this case misunderstand what's actually happening. A grand jury is not a routine step. It is not a box a prosecutor checks. Here is exactly what a grand jury does. A grand jury is a panel of citizens convened with the power to subpoena witnesses, compel testimony under oath, and review evidence that has not been made public. There is no defense attorney in that room. There is no judge moderating the proceedings. It is the prosecutor presenting evidence directly to the jury and asking them to determine whether there is enough to formally charge someone with a crime. In Mississippi, a district attorney has the clear legal authority to review a case, determine there is no evidence of criminal conduct, issue a public statement, and close the file. No grand jury required. No sealed autopsy necessary. No communication restrictions across every involved agency. If a case is clean, a prosecutor can say so and move on. McElrath did not do that. She chose the grand jury path. And that choice is itself a statement about what she believes this case contains. Now here is the part of her statement that cut through everything else. In that entire video, with every opportunity to offer clarity, with a grieving family watching, with a community demanding answers, she never once said 3 words. It was an accident. Not once. She did not say the evidence points away from foul play. She did not signal this case was heading toward closure. She did not use any language that suggested the investigation was wrapping up. Instead, she said every piece of evidence must be examined. She said every credible lead must be followed to its conclusion. She said every witness interview must be analyzed in the context of all other evidence. That is not the language a prosecutor uses when they are preparing to deliver difficult but final news to a grieving family. That is the language of active case construction. That is a prosecutor describing a process that is still building towards something. And in law, what a prosecutor chooses not to say is often more revealing than what they do say. She had the floor, she had the microphone, she had 3 weeks to prepare that statement, and she did not call it an accident. If this case is landing on you the way it's landing on me, subscribe to Detective Crime Hour right now. Because Chapter 3 of this video is where we break down what accountability in this case could actually look like. Not theory, specific charges, specific legal thresholds, specific documented facts tied directly to what prosecutors can realistically pursue here. If you want to understand where this case is actually heading, you need to be here for that. Subscribe now and keep watching, because we are not done. Now, 2 men looked at this same case. Same public record, same documented facts, same GPS data, same phone, same sealed autopsy, same grand jury referral. And they reached conclusions that are so far apart, the gap between them tells you something important. Former Mississippi Judge Carlos Moore. This is not an outside commentator speculating from a distance. This is a man who operated inside this exact legal system. He knows how Mississippi grand juries work. He knows the difference between what they are designed to do and what they are being used for here. And he has said publicly, with specificity, that the evidence already available on the public record justifies arrests. Not eventually, not after the grand jury convenes. Now, his argument is grounded in probable cause. We covered the legal threshold for that in Chapter 1. Enough reasonable documented evidence to believe a person may have committed an offense. Judge Moore's position is that the GPS data, the recovered phone, the 13-hour gap, and the conflicting accounts already clear that bar. He is not calling for a conviction. He is calling for arrests, for questioning, for pressure applied under conditions that carry legal consequence. Mississippi Governor Tate Reeves sees it differently. He has stated publicly that he has not seen a single fact or piece of evidence suggesting foul play. Not one. Same case, same public record, opposite conclusion. So here is the question you have to ask. Why would two people looking at identical information reach conclusions this far apart? And the answer has nothing to do with the evidence itself. Former Judge Carlos Moore no longer holds elected office. He has no constituency to protect, no political exposure here, no career calculation attached to what he says publicly about this case. He is speaking from entirely outside the system. A sitting governor is in a completely different position. This case has drawn national attention, federal scrutiny, formal institutional pressure, celebrity involvement at a significant scale. None of that is comfortable for a state already navigating a complicated public history around accountability in high-profile cases. One voice is speaking from inside a system that has structural reasons to want this resolved quietly. The other is speaking from outside that system entirely. That context does not tell you who is right, but it tells you exactly where each voice is standing when they speak. Now there is one more piece of evidence from this case that most people have moved past too quickly. The keys. After Nolan's death, his father attempted to retrieve his son's personal property. Standard process. Should have been straightforward. It was not. Nolan's father was required to formally identify his son's body in order to get the keys back. The process took 15 minutes. In a routine accidental drowning with no open questions, handing personal property back to a grieving family is not a 15-minute formal identification procedure. It just isn't. So ask yourself what that procedure was protecting. What documentation was being created? What chain of custody was being maintained around items that in a clean case would require nothing more than a signature? The answer to that has not been made public, but the procedure itself tells you those keys were not treated as simple personal belongings. They were treated as items connected to something still under active review. And then there is the FBI. Their involvement was confirmed specifically by the Jackson County Sheriff's Office. And here is the detail that matters. The FBI is not investigating the drowning itself. They are investigating interstate threats. Threats serious enough to cross state lines, serious enough to fall under federal jurisdiction. People connected to this case are being threatened. Think about what that tells you about the pressure surrounding every person who has information about what happened on Horn Island on July 4th. When threats in a case go federal, it means the stakes attached to what someone knows are significant enough that someone else wants them silent. That is the environment this investigation is operating inside right now. Local, state, federal, all working this case simultaneously, and the DA standing at the center of all of it holding a sealed file with a grand jury waiting to be convened. Everything she has done since Nolan's body was recovered points in one direction. She is not closing this case. She is building it. And what she is building it toward is exactly what Chapter 3 breaks down. When the grand jury speaks, here is exactly where this case stands right now. Not where people think it stands, where it actually is. The grand jury has not convened yet. That is the first gate. The second gate is toxicology. Two autopsies are in play here. The state autopsy ordered by investigators, and an independent autopsy commissioned by Nolan's family. Both have toxicology results still outstanding. Here is why toxicology takes this long and why it matters. Standard autopsy findings can be completed relatively quickly. Toxicology is different. It requires sending biological samples to a certified lab. Those samples are screened for a wide range of substances: prescription drugs, controlled substances, alcohol levels, carbon monoxide, environmental compounds. The full panel takes anywhere from 6 to 12 weeks depending on the lab and the complexity of what they are looking for. And here is the part that directly affects this case. Toxicology results can establish or challenge the cause and manner of death. They can confirm what the initial autopsy found, or they can contradict it. When two separate autopsies are both waiting on toxicology and both sets of results are still sealed, that process is not complete. And a grand jury cannot be fully briefed on a case where core forensic findings are still outstanding. Those results are the final piece the DA needs before that room convenes. Now let's talk about accountability, because this is where most people following this case have the wrong picture entirely. The conversation around this case has defaulted to one word: murder. And that framing is actually limiting the public understanding of what charges are realistically in play here. There are criminal charges that do not require proving what caused Nolan Wells to die. They require proving what happened after. And that is an entirely different legal calculation. Start with failure to report a death. In Mississippi, there is a legal obligation to report a known death to authorities within a reasonable time frame. 13 hours is not a reasonable time frame. The documented Coast Guard contact records show exactly when that call came in. If investigators can establish that specific individuals on that boat knew Nolan was dead or missing and made a deliberate decision not to report it, that is a chargeable offense. The evidence needed to support that charge is largely already in the record. The timeline, the Coast Guard timestamp, the accounts given by those who were present, move to tampering with evidence. This charge requires proving that someone knowingly altered, destroyed, or concealed physical evidence connected to an investigation. Think about the phone that was recovered. If forensic extraction shows that content was deleted from that device after Nolan went missing, and that deletion was deliberate, that is tampering. It does not require proving murder. It requires proving that someone touched evidence they should not have touched. Then there is obstruction of justice. This charge applies when someone knowingly provides false information to investigators or takes deliberate action to interfere with an active investigation. If the verbal account given to investigators contradicts the GPS data from the boat in any material way, that contradiction is not just a discrepancy, it is potential obstruction, and that evidence is sitting in the DA's sealed file right now. These three charges carry real legal weight, and they are prosecutable independent of what the toxicology results ultimately show about cause of death. That is the accountability framework Judge Moore has been pointing toward. That is what the grand jury will be evaluating. Now here is what the grand jury process actually looks like from the inside. Most people have a courtroom picture in their heads. That is not what this is. A grand jury meets privately. No cameras, no public access, no defense attorneys present. The DA presents evidence directly to a panel of citizens. She can call witnesses. Those witnesses testify under oath. And here is the part that changes everything for this case. Subpoenas. The grand jury has subpoena power. That means anyone connected to this case can be compelled to appear and testify under oath. Not informally. Not voluntarily. Compelled. Here is why that matters specifically here. In the early stages of this investigation, witnesses gave accounts to law enforcement in a relatively informal setting. Those conversations carry weight. But testimony under oath in front of a grand jury carries a different weight entirely. If someone's sworn grand jury testimony contradicts what they told investigators earlier, that inconsistency becomes perjury, a separate criminal offense. The grand jury will hear testimony that Nolan's own parents have not heard. They will review evidence the public has not been allowed to see. Everything the DA has been protecting inside that sealed file goes into that room. And the people who were on that island on July 4th will be asked to tell their story again. This time under oath. This time with consequences attached to every word. Now let's talk about the pressure surrounding this case from the outside. Because it is not coming from one direction. Al Sharpton, Tyler Perry, and Terrell Owens put $125,000 on the table. And the specific language of that reward matters. It is not for information about what happened. It is for information leading directly to an arrest and conviction. That distinction is deliberate. This is not a community trying to piece together a timeline. This is a direct, funded demand for criminal accountability. The NOC passed a formal resolution calling on the Department of Justice to conduct a full independent review of this case. That kind of institutional action does not happen around cases the federal government considers routine or resolved. When an organization with that reach formally requests DOJ oversight, it is because they believe the local process needs external accountability, and the federal layer is already present. The FBI confirmed. Interstate threats under active investigation. Local, state, federal, $125,000 reward, DOJ review request, 2 sealed autopsies, a grand jury waiting to convene. That is not the architecture surrounding a case heading toward closure. So here is the final assessment, plainly stated. The DA sealed the autopsy. She silenced every investigator on the case. She referred this to a grand jury when she had no legal obligation to do so. She used language in her public statement that signals active case construction, not case closure. She never once called it an accident. Prosecutors do not build that kind of structure around cases with nothing inside them. They seal things they intend to use. They silence investigators when the investigation is still sensitive. They convene grand juries when they believe the evidence they have can support criminal charges. This case is not pointing toward a quiet resolution. Every documented decision made by the DA points in one direction, toward a room where witnesses testify under oath, toward charges that do not require a perfect case, toward accountability for what happened on Horn Island and what happened in the hours after. Someone who was on that boat knows exactly what occurred during those 13 hours. They know what was said, what was decided, what was done. When the grand jury convenes, they will be asked to say it again, this time under oath, with a prosecutor in the room who has already seen everything inside that sealed file. And when that happens, this case moves. The toxicology results are coming. The grand jury date is coming. And when either one of those breaks, this story shifts fast. Subscribe to Detective Crime Hour right now, because the next update on this case is not a maybe, it is a when. And when it drops, you want to already be here. Hit subscribe, turn on notifications. This case is not over. It is just getting to the part that matters most.